Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Thank you for joining us for this post-decision episode of SCOTUScast, Immigration, Continued Detention, and Bond Hearings Edition. I'm your host, Bridget Flaherty. On February 27, 2018, the Supreme Court decided Jennings v. Rodriguez, a case involving a lawsuit by aliens challenging their continued detention under civil immigration statutes without the benefit of an individualized bond hearing as to the justification for ongoing detention. Alejandro Rodriguez, a Mexican citizen and legal permanent resident of the United States, was convicted of a drug offense and vehicular theft and ordered removed from the country. He was detained under Title VIII of the United States Code, Section 1226, which generally requires detention of aliens convicted of certain criminal offenses until removal proceedings are resolved. In addition to challenging his removal order, however, Rodriguez also sought habeas relief in federal court in the form of a bond hearing to determine whether his continued detention was justified. His case was consolidated with the related case, and after a round of litigation in the U.S. Court of Appeals for the Ninth Circuit, was certified as a class to address whether aliens in situations like Rodriguez, who had been detained longer than 6 months pursuant to an immigration detention statute, were entitled to a hearing to assess the justification for continued detention. They argued that the immigration statutes do not justify such detention in the absence of an individualized bond hearing, at which the government proves by clear and convincing evidence that the class number's detention remains justified. The district court granted the class injunctive relief along these lines, and the Ninth Circuit affirmed, relying on the canon of constitutional avoidance. The Supreme Court thereafter granted the government's petition for certiorari. This case was originally argued before the Supreme Court in November 2016, but the court thereafter ordered supplemental briefing, and the case was then re-argued in October 2017. The supplemental briefing directed the parties to address whether the alleged bond hearing requirement extended to aliens detained while seeking admission to the United States, to criminal or terrorist aliens, and how the proposed standard of proof applied to the bond hearing. By a vote of 5-4, the Supreme Court reversed the judgment of the Ninth Circuit and remanded the case. In an opinion authored by Justice Alito, the court held that the immigration provisions at issue, sections 1225B, 1226A, and 1226C of Title VIII, do not give detained aliens the right to periodic bond hearings during the course of their detention. The Ninth Circuit erred in applying the canon of constitutional avoidance to hold otherwise. That court should consider the aliens' constitutional claims on remand, but should first re-examine whether they may continue litigating as a class. Justice Alito delivered the opinion of the court except as to Part 2. The Chief Justice and Justice Kennedy joined Justice Alito's opinion in full, while Justices Thomas and Gorsuch joined as to all but Part 2, and Justice Sotomayor joined only as to Part 3C. Justice Thomas filed an opinion concurring in part and concurring in judgment, in which Justice Gorsuch joined except for footnote 6. Justice Breyer filed a dissenting opinion, in which Justices Ginsburg and Sotomayor joined. Justice Kagan was recused. And now, to discuss the case, we have Richard Samp, Chief Counsel of the Washington Legal Foundation.
In February 2018, the U.S. Supreme Court issued its decisions in Jennings v. Rodriguez, an important immigration case that addressed the authority of federal immigration officials to detain aliens while they determine whether those aliens may either enter the country or remain here. The case had been pending before the court for 2 years. Its resolution was the decision focuses solely on statutory issues. It rejected a Ninth Circuit interpretation of the relevant immigration statutes that would have made it easier for aliens to win release from detention pending completion of immigration proceedings. But it was the justice's views of the constitutionality of detention that appears to have driven much of the statutory analysis. The court split 5-4, with the 5 more conservative justices adopting a far broader view of the government's statutory authority to detain aliens. The 4 dissenters were quite open about their principal rationale. They read the detention authority in a very limited manner, because they concluded that a broader reading would have rendered the statute unconstitutional. In proceedings below, the Ninth Circuit had justified its similar narrow reading of the statute on that same constitutional avoidance rationale. As usual, it appears that Justice Kennedy may have played an outsized role in the court's decision, even though the majority opinion was written by Justice Alito. At one point, the court appeared poised to address the underlying constitutional issues. Indeed, following the initial oral argument in November of 2016, which focused solely on statutory issues, the court requested that the parties file supplemental briefs that addressed whether the extended detention of aliens pending completion of deportation proceedings violated their constitutional rights. It was at that point that Justice Scalia died. The court ended up being split 4-4 and carried the case over to its 2017 term so that Justice Gorsuch could participate. Although, as I said, the court had asked the parties to address the constitutional issues, Justice Alito's opinion, issued in February of 2018 for the court, declined to address whether the detention issues violated the constitutional rights of aliens. Alito said that the issue should be addressed in the first instance by the Ninth Circuit. It is reasonable to surmise that the court ducked the constitutional issue because Justice Kennedy was not yet willing to commit himself to the position likely espoused by his 4 conservative colleagues. And that position would have been that extended detention of aliens pending completion of removal proceedings does not violate their rights to due process of law. Thus, the constitutional issue initially raised by the Jennings case is not going away. It can reasonably be expected that on remand, the Ninth Circuit will hold that the detention statutes are in fact unconstitutional, at least as applied to some aliens. So I expect that the Jennings case or another case raising similar constitutional issues will be back before the court before too many more years. Because Jennings ducked the constitutional issue, the court's decision is less important than it might have been. Perhaps its greatest legacy is what it had to say about the constitutional avoidance doctrine. Some lower courts have liberally applied that doctrine when interpreting a statute. They have adopted highly strained interpretations of statutes based on a belief that the statute would otherwise be unconstitutional. The court's majority in Jennings flatly rejected that approach. It held that the doctrine of constitutional avoidance only can come into play if it can be found susceptible of more than one plausible interpretation. It criticized the Ninth Circuit for invoking the doctrine when the alternative interpretation ultimately adopted by the Ninth Circuit was not really plausible. Jennings is also significant because it strongly suggests that lower courts should refrain from entering class-wide relief, as the Ninth Circuit did here. Instead, Jennings counseled, courts should decide the constitutional claims of aliens on a case-by-case basis. Although the details of the statutory provisions at issue in Jennings are perhaps of not great interest, let me quickly summarize the statutory provisions that were addressed in the case. At issue in Jennings was detention of 2 different groups. First, aliens intercepted at the border who seek to enter the country. And secondly, aliens who are already in the country but are subject to removal because they have committed a serious crime. Detention of the first group is covered by 8 U.S.C. Section 1225A, which generally provides that such aliens can be turned away if they cannot demonstrate a right to enter. But if they can make out at least a colorable claim that they face persecution at home and thus may be eligible for asylum, they can generally be held in detention until their asylum claims are fully adjudicated. While in practice many such aliens are released on a discretionary basis, the statute does not grant them a right to a bond hearing. The cases of aliens subject to removal because of criminal convictions is somewhat more complicated. Most such aliens are entitled to a bond hearing under Section 1226A, and they can be released pending completion of immigration proceedings unless officials determine that they are a flight risk or are likely to commit another crime if released. But if they have been convicted of a particularly serious crime, Section 1226C states that they must be detained pending completion of proceedings. For most of our nation's history, federal law has provided for the removal of aliens convicted of serious crimes, but it granted the executive branch discretion to waive deportation in exceptional cases. Congress eventually concluded that the system was ineffective in assuring removal of criminal aliens. Large numbers of convicted criminals claimed that theirs were exceptional cases. Moreover, when they were released from detention while their appeals were pending, more often than not, they absconded rather than report for deportation following rejection of their appeals. Congress finally had enough. To ensure that criminal aliens were in fact being removed from the country, Congress tightened the law in 1996. The 1996 law included Section 1226C's mandatory detention provision. Several alien felons challenged the new law, but the Supreme Court upheld its constitutionality in 2003 by a 5-4 vote in a case by the name of Damore versus Kim. Some lower federal courts, particularly the Ninth Circuit, have never fully accepted the Damore decision and have repeatedly sought ways to avoid application of 1226C's mandatory detention provision. In the Jennings case, the Ninth Circuit held, first of all, that Damore only applies to detention lasting 6 months or less, and secondly, that 1226C would violate aliens' rights under the Due Process Clause if it were interpreted as prohibiting any possibility of release throughout the sometimes lengthy appeals process. And third, the Ninth Circuit held that applying the constitutional avoidance doctrine to the statutory interpretation question, 1226C should be interpreted as containing exceptions. That is, it should be understood to mandate release of an alien whose removal proceedings have lasted more than 6 months unless immigration officials can demonstrate by clear and convincing evidence that the detainee is either a flight risk or a danger to the community. The Ninth Circuit went on to apply the same rationale to entering aliens under Section 1225. In other words, it held that they too, after 6 months, are entitled to a bond hearing. The court majority would have none of that. It held that the statutes contain no exception, that there is no right to a bond hearing, and it criticized the Ninth Circuit for essentially making up that right to a bond hearing. However, as I said, Justice Kennedy was not willing, apparently, to go on and decide the constitutional question, so the court remanded the case back to the Ninth Circuit for an initial determination of the constitutional issue. And for that reason, as I've said before, the case is not going to go away. The Ninth Circuit almost surely is going to hold, as it intimated before, that it thinks that due process requires that detained aliens after 6 months have a right to a bond hearing, and I suspect that the case will be back before the Supreme Court in another couple of years. Perhaps the most enduring legacy of the court's decision is, as I've mentioned, number one, it criticized the too liberal use of the constitutional avoidance doctrine. The court said that federal courts need to interpret statutes in a plausible manner. They can't make it up simply as a way of avoiding deciding a constitutional issue. Secondly, the court, in pretty stern language, pointed out to the Ninth Circuit that the immigration laws include a provision that pretty strictly limit the right of federal courts in immigration cases to grant relief on a class-wide basis, and it strongly suggested that the Ninth Circuit on remand ought to decertify the class that it had certified, and therefore it's highly probable, I think, that although the Ninth Circuit is probably going to find in individual cases that prolonged detention violates due process rights, that the Ninth Circuit is probably going to feel compelled not to grant relief on a class-wide basis. If so, I think that probably will go a long way to eliminate what I view as the mischief of lower courts entering these class-wide remedies that end up applying not just to individual cases, but to all immigration cases, and therefore you will probably find that the process of detention of criminal aliens probably will be less interrupted than it has been in the past by lower courts such as the Ninth Circuit. There, in fact, is another case that is pending in the Supreme Court this coming term that is likely to once again slap down the Ninth Circuit for its too liberal reading of Section 1226C. That's a case by the name of Nielsen versus Priap. And I think the combination of the decision in that case, that it's likely to be forthcoming next term, as well as this term's Jennings decision, should go at least some of the way in cutting back on, shall I say, venturesome decisions by the Ninth Circuit.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.